The judgment is ready. It will be read shortly. This is the judgment of the court. The claim of the claimants against the defendant jointly and severally filed on the 10th day of July 2018 as per paragraph 19 of the statement of fact is as follows. A, the sum of 630,000 naira for each from 30th day of June 2015 to 31st day of May 2018, amounting to the total sum of 3,780,000 naira, being allowance stroke salaries owed to them by the defendants. B, the sum of 10 million naira as compensation stroke payoff for the hardship and prostration they have been subjected to daily with their families. C, the sum of 1 million naira for cost of litigation. D, 10% interest on the judgment sum from the date of judgment until the entire judgment sum is paid to the claimant. Upon being served with the originating process, the defendants filed their statement of defense and counterclaim on 21st day of March 2019. The claimants filed their reply to the defendant's statement of defense and counterclaim on the 7th day of May 2019. The defendants, with the leave of court, amended their statement of defense and counterclaim. The amended statement of defense and counterclaims were filed on the 28th day of November 2019. The defendants, in paragraph 22 of their statement of defense, counterclaim against the claimants as follows. A declaration that the Cross River State government is entitled to possession of kits issued to the claimants, such as 1, 2 pairs of shirts, 2 pairs of trousers, 3, 1 uniform belt, 4, 1 lanyard, 5, 1 whistle, 6, 1 headgear cap, 7, 2 reflective vest, 8, 1 pair of boots, 9, 1 pair of socks, 2, an order directing the claimant to return the said kit to the Director General of the first defendant within 3 days of the delivery of judgment in this case. 3, alternatively 5 million naira as cost of the items retained by the claimants. 4, 10 million naira for the illegal use and detention of the said items in the case of 6 claimants who ceased to be an ad hoc staff of the first defendant in 2013. 5, 30 million naira for the illegal use and detention of the said items in the case of the first, second, third, fourth, and 5th claimants who ceased to be ad hoc staff on the first defendant in 2015. 6, the sum of 10 million naira exemplary damages. 7, 30 million naira general damages. 8, 10% interest per month on any sum awarded against the defendant to this counterclaim as judgment debt. 9, an order of perpetual injunction restraining the defendants to this counterclaim from using the kits and parading themselves as road marshal of the first defendant. The claimants returned on the 4th of February 2020 filed a reply to the defendant's amended statement of defense and counterclaim. Mr. Epiom Edet Okon, the second claimant, testified in proof of the claim of the claimant as CW1. CW1, after identifying his two-witness statement on oath, adopted same as his evidence. Exhibits were tendered in evidence through CW1, and they were admitted in evidence and marked as Exhibit A to F. Mr. Francis Obi, a member of staff of the first defendant, testified in proof of the defense and the counterclaim as DW1. DW1, after identifying his witness statement on oath, adopted same as his evidence in this case. Documents were tendered in evidence through DW1. They were marked as Exhibit D1 to D7. The case of the claimant, due to time constraint, I will skip reading the case of the claimant. Counsel will have the benefit of seeing it when they collect the hard copy. Then the case of the defendants also, I will skip reading it. There is also the submissions of the reply to the amended statement of defense. There is also the submissions of the defendants where 3 issues were formulated. I have captured the 3 issues and argument canvas in respect of those issues. Then the submissions of the claimants. Please, we should mute so that there should be no disturbances coming in, please. We should mute our microphones. The claimants also formulated 3 issues. I have captured the 3 issues and the argument canvas in respect of the issues. So I will skip reading all those submissions. I go straight to the decision of the court. I have carefully and painstakingly considered the processes filed in this suit, the evidence laid by the parties, as well as the written submissions of counsel for the parties. The gist of the facts that led to the filing of this action, as can be gathered from the processes filed, are that the claimants were employed by the first defendant as ad hoc road marshals by the first defendant. The 4th and 6th claimants were employed in the first batch of ad hoc staff employee of the first defendant, while the 1st, 2nd, 3rd, and 5th claimants were employed as ad hoc road marshals in the 2nd batch of employment. Upon their recruitment, the claimants undergo a compulsory military and paramilitary training by both the Nigerian Army and the Nigerian Police Force, as well as training seminar by university lecturers. Immediately after the training, the claimants were posted and payroll and paid each of them allowances salaries monthly in the sum of 18,000 naira. The claimants were last paid honorarium allowance salary in June 2015. The claimants were never suspended or terminated till date. The claimants asserted that they are still in the employment of the defendants and they are entitled to their salaries. They also asserted that they were promised to be absorbed and converted into permanent staff, but the claimants have refused to absorb them as permanent staff despite being qualified for absorption into the civil service. The defendants have also stopped paying claimants their salaries and refused to pay arrears of their salaries. The defendants on their part have maintained that the claimants were employed as ad hoc road marshals and have been paid last in June 2015. The claimants were not absorbed because they failed to or refused to appear for examination, interview, and certificate verification conducted to absorb ad hoc staff of the first defendant into the civil service of Cross River State. The defendants also stated that some ad hoc staff employed together with the claimants who have qualified and appeared for the interview and certificate verification were all absorbed into the civil service. And at the end of the exercise, the claimants were disengaged and asked to return kits issued to them during the period of their employment, and were asked to return the kits, but they have failed and refused to do so. The claimants retained the kits and were using them to extort money from unsuspecting motorists. The claimants approached this court to claim payment of the sum of 3.7 million naira as allowances / salaries owed to them by the defendant. They are also claiming the sum of 10 million naira as compensation / payoffs for hardship frustration. They are also claiming the sum of 1 million naira cost of litigation and 10% interest on the judgment sum from the date of judgment until the entire judgment sum is paid to the claimants. It is clear to me from the facts as revealed by the pleading and evidence before the court, the main reliefs being sought by the claimant is the reliefs number A, which centers on payment of the sum of 630,000 to each of the claimants, which total to the sum of 3,780,000, being allowances and salaries owed them by the defendant, while all the other reliefs are ancillary dependent on grant of the main reliefs. The defendant in their final written address formulated 3 issues for determination. The claimant also in their amended final written address formulated 3 issues for determination. After careful appraisal of the issues formulated by the parties, I am of the view that the issues formulated by the defendant are all encompassing to cover all the issues raised by the claims and the counterclaims of the defendant. In the circumstances, I adopt issues formulated by the defendants as the issues calling for determination in this case. It is to be noted that issue number 1 raised by the claimant is not appropriate for determination of the reliefs being sought, as there is no reliefs on wrongful termination of a claimant's employment. It is interesting to note that the reliefs being sought in this suit borders on payment of arrears of unpaid allowances, stroke salaries, compensation for hardship, payoff for hardship and prostration. They have been subject to which the claimant have been subjected to cost of litigation and interest in the rate of 10%. There is no relief on whether claimants have been appropriately relieved of their appointment or not. Therefore, issue 1, as formulated by the claimant, is not within the contemplation of the issues raised by the claim of the claimant. I now consider the issues as argued. Issue 1, whether from the facts and circumstances of this case, the claims of the claimant are statute barred. In arguing this issue, the defendants have argued that the claimant's action as it is presently constituted is statute barred, as it was not instituted within the prescribed period of 6 months for action to be instituted against public officers as provided for by Section 1A of the Public Officers Protection Act of Cross River State as amended. According to the defendants, the alleged stoppage of payment of salaries was in June 2015, and this action was instituted before this court in July 2018. Which means this suit was brought to court 2 years after the accrual of the course of action, which is beyond the period of 6 months allowed by Section 1A of the Public Officers Protection Law of Cross River State. The action therefore becomes destitute of right of action and judicial relief as the course of action has been extinguished. On their part, the claimants on their parts have argued that this suit was duly filed in 2018 when the claimants approached this court to challenge their unpaid arrears of salaries, more so when the claimants were not dismissed on their contract of employment terminated. They also argued that their claim being predicated on services rendered is not caught by limitation law. Resolution of the issue. The defendant's position on the claim of the claimant is that it is statute barred for having been instituted beyond 6 month period prescribed by Public Officers Protection Law of Cross River State as amended, while the claimant insisted that the defendant's objection is baseless as it was based on the conception of law and fact constituting the course of action given the claimant's right of action. When a party in a suit alleges that an action is started by it is in effect saying that the legislature has prescribed certain period of limitation for instituting action. The statutes that prescribe such period and regulate the substance of the course of action are known as statutes of limitation, where a statute of limitation prescribes the period within which an action must be must be commenced. Legal proceeding cannot be properly or validly instituted after the expiration of the period provided by the statute. Where an action is started by a claimant who might otherwise have had a cause of action loses the right to enforce it by judicial process because the period of the time laid down by the limitation law for instituting such an action has elapsed. See the case of Eboige versus NNPC. See also Oduepo versus Paula. See also Sanda versus Kukawa local government area. See also Ekiagu versus Aliri. Generally, to determine if an action is started by, it is the originating process that the court should look at to find out the date, the wrong that caused the suit occurred, and the date the suit was filed before the court. But where the objection that a suit is started by is considered and determined after the conclusion of the evidence by both sides, as in this case, all the processes and evidence before the court must be considered, especially where the objection is determined as part of or along with the final judgment on the merit of the dispute in the case. This approach pursues the substantial justice of the matter and reduces the incidence of unscrupulous litigants who, knowing very well that their claim is already started by, praises their case in such a manner as to hide or misrepresent that fact to explain the principle that only the originating process should be considered in determining the issue when cause of action accrued and abuse of process of court. In this case, the limitation law was raised in the pleading. This means this court is obliged to look at the entire process processes and evidence adduced in the course of the trial to determine when the cause of action accrued and whether the suit was started by or not. See the case of APC versus Lere. See also Idigbe versus Ade Parasin. See Unwekwere versus Adewumi. See also Idigbe versus Alhaji. It is tried that where the law prescribes a period for instituting an action, proceeding cannot be instituted after the period prescribed by law has elapsed. See INEC versus Ogbadibo local government area and others. The courts have over the years stated the rationale for or justification supporting the existence of statute of limitation, which is to ginger a person with the cause of action to pursue them with a reasonable diligence, as long as dormant claims have more of cruel than justice in them. Also, evidence may have been lost, thereby posing problem of proving a stale claim. A period of limitation begins to run from the date on which the cause of action accrued. Therefore, in order to determine whether an action is started by, all that is required is for one to examine the writ of summons and the statement of claim alleging when the wrong was committed, which gave the plaintiffs a cause of action, and comparing that day with the date on the writ of summons when it was filed. If the time on the writ is beyond the period of allowed by the limitation law, the action is started by. See Idigbe versus Ade Prasin and host of other cases cited therein. Military Administrator by Ekiti versus Adeyelu. See also Attorney General of Adamawa State and others versus Attorney General of the Federation. See also Mohammed versus Military Administrator of Plateau State. see British Airways PLC versus Akinyi Shoye, see Ida Chaba versus Federal University of Agriculture Makodi, see also INEX versus Ogbadibo. It is manifestly clear from the processes filed by the parties and evidence adduced in the course of the trial. The claimants were last paid their allowances salaries in June 2015, and this suit was instituted by the claimant on 10th of July 2018. This means it took the claimants over 2 years to commence this action. This also means that the claimant's action was not commenced within the 6 months period allowed by the Public Officers Protection Law of Cross River State as amended. The claimant has admitted not bringing this action within 6 months period prescribed by Section 1A of the Public Officers Protection Law as amended. That's why the claimants argued that their case falls within the exception to the applicability of Public Officers Protection Law, as their claim is for work done at labor and it is for continuance of damage or injury. It should be noted that the purpose of Public Officers Protection Act is meant to protect officers in civil liability for any wrongdoing that occasion damages to any citizen if the action is not instituted within periods stipulated by law after the act, default or neglect complaint of. See Yabuge versus Commissioner of Police, where the statute has provided period within which an action can be commenced. Proceedings shall not be brought after the expiration of the period. Any action instituted or commenced after the period prescribed by has prescribed for its commencement will be statute barred. See Ibrahim versus Kaduna State Judicial Service Commission. There is no dispute in the fact that this suit is claiming for arrears of unpaid salaries, which means the claim is based on contract of service, labor, and work done. This means the provision of Section 2A of the Public Officers Protection Law of Cross River State, which provisions as impari materia with provisions of Section 2A of Public Officers Protection Act, save the period of limitation, which is 6 months and 3 months respectively, are inapplicable to the case in hand because the matter under discourse and review pertains to claim for work and labor done, which is an exception to the applicability of limitation law. See the case of Attorney General of River State and Attorney General of Bayelsa State. See also the case of Nigerian Port Authority versus Constrazioni Basura Kogefa. See also the case of National Revenue Mobilization, Allocation and Fiscal Commission and others versus Ajibola Johnson and others. There is no doubt a careful reading of the claimant's claim will show clearly that it is based on contract of service. It is now settled law that Section 2A of the Public Officers Protection Act does not apply to cases of contracts. See Nigerian Port Authority versus Constraziani. See also Osun State Government versus Delami Nigeria Limited, and the case of National Revenue Mobilization versus Johnson Sufra. On the whole, issue 1 is resolved in favor of the claimants against the defendant. This case is not statute bar as it falls within the exception to the applicability of Section 1A of the Public Officers Protection Law of Cross River State. I so find and hold. Issue 1 has been resolved in favor of the claimant. As this suit is not caught by statute of limitation, I now go to the issue 2, whether from the evidence, facts, and circumstances of this case, the claimants are entitled to the relief sought in this suit. The defendants, in arguing this issue, submitted that a party who approaches the court to enter judgment in his favor on the basis of facts asserted ought and bear the burden of proving those facts to the satisfaction of the court and with preponderance of evidence. The counsel for the defendant has also argued that the court has also urged the court to dismiss the evidence of CW1 with regard to the claims of first, third, fourth, fifth, and sixth claimant as evidence upon which this court could act upon on the ground that the said evidence is hearsay and inadmissible by virtue of Section 37 and 38 of the Evidence Act 2011. Counsel also argued that the Exhibit C and D, being uncertified secondary copies of purported public documents, are inadmissible in evidence and ought to be expunged from the record, as the only admissible secondary evidence of public document is a certified true copy. Counsel further argued if the evidence of first, third, fourth, and fifth, and sixth fifth claimants are discountenanced, their claims are deemed to have been abandoned and their claims liable to be dismissed. It is also submitted that claimants who were ad hoc road marshals of the first defendant have no automatic right of absorption into the civil service of Cross River State when they failed and refused to submit themselves for interview and screening. Counsel also argued that the claimants were duly given notice of termination of appointment when upon absorption of qualified ad hoc staff as permanent staff, the other ad hoc staff who failed to present themselves and their certificate for screening or were unsuccessful were requested to return the items issued to them when they were engaged by the first defendant as ad hoc staff, as their services were no longer required. The claimants, from the time they were asked to return items issued to them, ceased to be ad hoc staff of the first defendant and cannot lay claim to payment of allowances and salaries for the period they did not work for the defendant. Counsel also argued, assuming but not conceding, that the claimants were entitled to be given any notice in any manner whatsoever, other than by the means adopted by the defendants before terminating their employment as ad hoc staff. Counsel submitted the law is settled that in assessing damages to be awarded to the claimants whose employment require notice before termination, the measure of damages is the amount they would have earned or entitled for the period of notice. It is submitted that the sum of 630,000 claimed by each of the claimants for the period starting from June 30th to May 2018 as allowances and salary, and as allowances and salaries owed them by the defendant cannot be said to be claimed for allowance and salary on the basis of work done by them for the defendant. This is because upon absorption of qualified ad hoc staff as permanent staff into the civil service of the defendant in 2016, the claimants and their unsuccessful ad hoc staff were asked to return items issued to them when they were engaged as ad hoc staff of the first defendant. Exhibit C and D are inadmissible as the documents are undated and unsigned. They should be expunged from the record of the court. It is further submitted that the claim of 630 to each of the claimants is in the nature of special damages, which by law must be specifically and specially pleaded with particularization and must strictly be proved before granting the claim. According to counsel, claimants have woefully failed to strictly prove their claim with credible evidence. On the claim of 10 million compensation, it is submitted, being special damages, it must be strictly proved. The claimants, having not strictly proved their claim, are not entitled to any compensation, as there is no evidence in proof of the alleged hardship they suffered. On claim for 1 million cost of litigation, this is at the discretion of the court. However, the discretion must be exercised judicially and judiciously. In concluding his submission on this issue, counsel asked the court to refuse the claim of the claimant and dismiss them. In arguing this issue, the claimants have submitted that it is settled law that the employer must do so by way of a valid letter of termination issued to the employee or a month's salary in lieu of notice. In this case, no such letter or payment of 1 month's salary, no termination as required by law. Section 11 of the Labor Act provided notice must be clear, as non-payment does not amount to the termination of contract of service. Counsel also submitted that the claimant's claim have proved their case by exhibit A, B, C, D, E, and F, as claimants have not been paid allowance salary for 65 months from the last date of payment in June 2018. There is also evidence that they have been posted by the first dependent. There is also evidence they were never dismissed or terminated till date. Resolution of issue 2, the main claim of the claimant is as per relief A, which is claiming the sum of 630,000 to each of the claimants as from June 2015 to 2018. The second relief being sought is for the sum of 10 million compensation for hardship. There is a relief C, which is for the sum of 1 million cost of litigation, and the relief 4 on interest of 15% of the judgment sum till relief is granted. During the trial, only CW1, the second claimant, testified in proof of the claim before the court. The defendants have also urged the court to discountenance the evidence of CW1 insofar as it affects the claimants who have not satisfied in the course of the trial, as according to counsel, the evidence is hearsay. Counsel also asked the court to expunge the exhibit C and D from the record of the court, as the said exhibit are not exhibited as the said exhibit are not admissible in evidence due to lack of certification as required by law. I shall resolve this twin preliminary objection raised by counsel for the defendant before delving into the resolution of the main question for determination. On the submissions by the defendants for the court to discountenance evidence of CW1 as it relates to first, third, fourth, fifth, and sixth claimants, as the said evidence is hearsay and inadmissible by virtue of section 37 and 38 of the Evidence Act 2011, and the failure of the first, third, fourth, and fifth, and sixth claimants to appear in court to testify for themselves amount to abandoning their claim. Let me say that there is no law prescribing a party Let me say that there is no law prohibiting a party from calling a particular witness or witnesses of his own choice in aid of his or her case. In the instant case, the assertion by the counsel for the defendant that apart from CW1 who testified, other persons, claimants who did not appear before the court to testify are deemed to have abandoned their pleading, cannot be correct. The witness that has testified had stated that the other claimants on record have mandated him to give evidence on behalf of all the claimants. This clearly goes to show that the evidence given by CW1 is in proof of the pleadings of all the claimants before the court. The claimants are free to call witnesses of their choice, as there is no law that says all the claimants must appear in person to testify in proof of their respective claims. All that is required or needed is adducing qualitative evidence in proof of the case before the court. See the case of Bello versus Kasim. See also Ali versus Ade Siloye. See also Ramaton Services Limited versus Inem. Furthermore, a law except where a statute prescribes otherwise, it is not the number of witnesses a party calls that entitles the party to what the party claims before the court. It is the quality of the evidence that is given by the witness or witnesses that matters. One witness may be enough to prove a case. In other words, a case is not necessarily proved by quantum of evidence since all he is required to do is to call sufficient evidence capable of establishing the facts as alleged by him. Yet, where a witness whose evidence would be crucial to settle an issue of fact one way or the other, and thus vital witness, such a witness should be called, and if he is not called, it will be fatal to the case of the defense or the parties that ought to have called the vital witness to testify. It is right to know that a litigant need not to call any particular number of witnesses. Once he has called the number of witnesses which he required to provide his case, except that failure to call a vital witness would be fatal. See Ali and another versus Ade Siloye. This where the Supreme Court held thus: the requirement of law from party to a suit is to call evidence in proof of his or her case. See also the case of Iyere versus Bendel Feed and Flour Mills Limited. See also Okunade versus Kolawole versus the state. See also Fall Eneche versus People of Lagos. In the circumstances the CW1 is qualified as witness in this case, and he can testify in proof of his case and that of his co-claimants. The second preliminary issue centers on the submission by the defendants, urging the court to expunge Exhibits C and D from the record of the court on the ground that being uncertified secondary copies of public document are inadmissible in evidence and ought to be expunged from the record, as the only admissible secondary evidence of a public document is a certified true copy. By paragraph 12 of the statement of claim of the statement of claims of facts of the claimants, the pleaded copy of first dependent ad hoc operative titled DOP, Department of Public Transport ad hoc operatives, This document was tendered in evidence and it was the claimant have also pleaded copy of paste dependent posting titled DOP posting. This document was tendered in evidence and marked as Exhibit D. Claimants have also pleaded copies of paste dependents October 2013 allowances, First Bank of Nigeria PLC payment list and EcoBank payment list. These documents were tendered and admitted in evidence and marked as Exhibit A and F. In Ukana versus COP, in the case of Lilly versus Pratt, the officers were held not to be non-public, documents because they were kept for the use and information of public, but for the information of the Crown and the executive. In Leonuo versus Demetrio, it was held a document to be admissible as public document. It should not only be available for public inspection, but also have been brought into existence for that purpose. In Agbai versus INEC, it was held that a press release is not a public document. See also section 102, 103, 104, and 104 of the Evidence Act 2011. Having regard to the above case law and the provisions of the Evidence Act, it can be said that Exhibit C and D already admitted in evidence before the court without any objection are a perusal of the authorities cited above and the relevant provisions of Evidence Act on the issue. I have no doubt in my mind that Exhibit C and D are not public documents. The reason being that the documents were not made for public purpose. Exhibit C is a table showing names, rank, and telephone numbers. There is nothing in it indicating that it was made for public purpose, to which a copy for Exhibit D, it is titled DOP posting. This document is showing posting of officers contained therein. The document was meant to notify the officers of the duty first and what is expected of them. This means that the document was not meant for the public consumption, but for the attention and notice of the officers concerned. In the circumstances, it is not public document that will require certification. On this note, the objection on the ground of the objection to Exhibit C and D on the ground that they are not public officers are failed, and same is misconceived and is hereby struck out. The next question to be asked is what is the evidential value of Exhibit C and D in this action? The law is well settled that there is a distinction between admissibility of document and A careful perusal of exhibits C and D will clearly show that the authors of this document were unknown, and there is nothing to indicate that the authors have signed or dated the document. Thus, this means that being unsigned and undated, they are worthless without any weight to be attached to them. Of course, by law, a document which does not carry the signature of the maker or writer is of no probative value and is worthless. The authorities on this are replete. See, for instance, the case of Brewtech Nigeria Limited versus Akinao and another. See also Governor of Lagos State versus Ohio Nigeria Limited. See also where an unsigned document is inadmissible to prove a claim to proprietary legal interest based thereon. In the instant case, Exhibit C and D, being unsigned and undated, must be rejected, as in this circumstance, the document would have had no effect whatsoever on the proceedings before the court. See the case of Ojo versus Adejobi. See also SPDC Nigeria Limited versus Olarewaju. The courts have been consistent in holding that documents which do not bear signature of their makers should attract little or no weight. An unsigned document is lacking in value and is worthless. An instrument that is unsigned is inadmissible. See Junadu versus It must be noted that an unsigned document is admissible if it is pleaded, depending on the circumstances of the case. In the instant case, Exhibit CD were properly admitted in evidence, but being unsigned had no probative value, and they are worthless as an adjudicative tool to arrive at any finding of facts. See the case of Paro Bottling Company versus Osuji. See also MS Company versus Enemaku. See also Attorney General Abia State versus Agaranya. See also Pashehun versus Attorney General of the Federation. A law and unsigned document is a documentary hearsay, particularly one tendered by a person who is not the maker of such as in this case. CW1 is not maker of Exhibit C and D. A court of law is under a duty to act on admissible evidence only, reaching its finding and conclusions in any matter before it. Thus, it has a duty to even expunge and or discountenance evidence which though earlier admitted, but which at the judgment writing stage turns out either in the final address of counsel or on the study of the court to be inadmissible, so that the matter is decided on admissible evidence only. See the case of Buhari versus Obasanjo, where the Supreme Court stated that hearsay evidence is inadmissible and it need not to be controverted before it is expunged from the record of the court. See also UBN versus Ishola, see ECPO versus State, see Omega Bank Nigeria Limited versus OG versus in any event, as pointed out earlier, in this judgment, the source of Exhibit C and D are not known. They would by a Zuru K versus 7-Up Bottling Company PLC qualify as documentary hearsay, especially as the makers are unknown. On the whole, and for the reasons given above, I hold that Exhibit C and D are inadmissible and so have no evidential value. They will be discountenanced for purposes of this judgment. I find and so hold. I now turn to the determination of the main issue in the claimant's claim, that is to say whether from the evidence, facts, and the circumstances of this case, the claimants are entitled to the reliefs sought in this suit. It is cardinal principle of our jurisprudence that the parties as well as the court are bound by the claim put forward before the court for adjudication, and a claim is circumscribed by the relief sought, and the duty of a claimant, therefore, is to plead only such facts and materials as are necessary to sustain the reliefs and adduce evidence to prove same. See Gabriel Atibi. It is also tried law that he who asserts the affirmative has a duty to prove same. There is no duty generally on a party to prove the negative. See the case of Imonike versus Unity Bank PLC. In the case at hand, the main principal relief of the claimant is for payment of the sum of 630 to each of the claimant being claimed for arrears of unpaid salaries, allowances from date of stoppage in June 2015 to May 2018 by the decision in the cases of 7-Up Bottling Company versus Augusto, NNPC Kilipo Nigeria Limited. A claim for salary is a claim for special damages, which is a law which requires that it must be specially and specifically pleaded, particularized, and proved strictly. The claimants, in an attempt to establish entitlement to arrears of unpaid salaries, tendered Exhibit A, B, C, D, and F. According to the claimants, the combined effect of all these exhibits is that claimants are entitled as still employee of the dependents whose contract of service have not been terminated or dismissed by any notice or payment of salary in lieu of notice. The facts of this case, as disclosed by the pleading and evidence of the parties, appears to me to be unique in that the employment relationship between the claimant and the dependents were not formalized as the court is left in the dark as to the nature of the employment relationship between the parties. In the circumstances, since there is no law governing the employment of the claimants, which is the first dependent as the said employment is based on an ad hoc arrangement, therefore, this case fits into the traditional contract of employment governed by employment. The facts of this case, as disclosed by the pleading and evidence, of the parties appears to me to be unique in that the employment relationship between the claimant and defendant were not formalized, as there is no any written agreement on the relationship, and none of the parties has tendered or even made reference to the terms and conditions of service. The court is left in this case, parties are all agreed that the claimants were employed as ad hoc road marshals in 2 batches, and some of them have been absorbed into the civil service of Cross River State as permanent employee, as permanent and pensionable staff. According to the defendants, with the absorption of some of the ad hoc staff, the unsuccessful ad hoc staff, including the claimants, were asked to return items issued to them as their services were no longer required. As pointed out, the position of the law is that either party in a master-servant relationship may bring it to an end, subject to giving notice or making necessary payment in lieu of notice under the terms of contracts. As pointed out, the position of the law is that either party in master-servant relationship may bring to an end, subject to giving notice, making necessary payment in lieu of notice under the terms of the contract. Once either of this is done, a servant cannot complain. See Akimpe versus UBA. See also SPDC Limited versus Olarewajo. See also Organ and others versus Nigeria Liquefied Natural Gas. Notwithstanding this position of the law nevertheless recognizes that in master and servant relationship, termination of the employment can be done orally or in writing or by conduct. See Ipeta Shell Petroleum. All that is required on part of the employer is action that all that is required on part of the employer is action that will convey termination. An employer has a choice of either dispensing with the services of his or her employee expressly or by implication. See the case of Ofuto versus NNPC. See also Ipeta versus SPDC Nigeria Limited. It is to be noted that once intention to terminate is conveyed, that is enough. Where there has been breach of non-compliance with terms and conditions that cannot invalidate termination or give room to employee to reject it, as court cannot hoist an unwilling employee on willing employer. See Adeboye, Sunday, Joseph, and others versus Kwara State Polytechnic and others. It is right law that a servant or employee whose employment has been terminated cannot claim salary for the period he was no longer in employment. See the case of Supreme Bank versus Babatunde. See also Obot versus CBN. An employee dismissed or terminated cannot choose to treat the contract as subsisting and claim for salaries and entitlement he would have earned. Applying the above enunciated principles of law in labor law to the case at hand, I have no doubt in my mind that the absorption of some of the ad hoc staff of the first dependent into permanent employment of the first in the civil service of Cross River State has ended the employment of the defendant to terminate claimants the intention of the dependent to terminate claimant's employment crystallized with the stoppage of the salaries of the claimant in June 2015, notwithstanding absence of a written letter of termination or payment of salary in lieu of notice. The reason being that there is no terms and conditions of service produced before the court in which the parties have agreed that termination must be in writing or by payment in lieu of notice. Section 11 of the Labor Act does not apply to the claimants as they are not captured in the definition of worker provided under Section 91 of the Labor Act. The claimants are also of the view that the absence of letter of termination means that they are still in service of the claimant salaries from the period of stoppage. As pointed out earlier, an employee is not entitled to salaries for work not done. The claimants have not tendered any concrete evidence before the court to show that they were working for the defendants for the period they are claiming payment for 35 months allowances and salaries. The documents they place reliance on to show that they are still employee entitled to salaries. Exhibit D, posting has been discouraged, has been discountenanced for not having been valued and being worthless due to absence of signature. Exhibit C for not having evidential value and being worthless due to absence of signature. Exhibit D, apart from suffering from lack of having author, it has been tampered with as there are a lot of biro used to asterisk or ticks some of the content of and outright writing with biro, which the court expunging Exhibit D from its record. There is no evidence to establish the claimant worked for the defendant for the period of claim. To further make the evidence in Exhibit D worthless, there is no indication of the period it covers. A careful perusal of Exhibit E and F cannot also serve as evidence to prove claim of the claimant. These exhibits, being letters of demand, can only establish that there was a demand, but not proof of what was demanded. The claimants have not proved or established that since the stoppage of their salaries, they have been working for the defendant. The failure to establish that the claimant have been working for the defendants since stoppage of their salary means that they are not entitled to payment for the period they did not render services to the defendant. For the claimant to succeed on payment of salaries, they are duty bound to show that they have worked for the period of claim. The mere fact that a party is employee of an employer alone cannot entitle that employee to salary. There must be evidence that the employee worked for the period, he worked for the employer for the period to earn salary for the period of his claim. In Honica Sawmill Nigeria Limited versus Hof, it was held as between an employer and an employee. The onus is on employer to prove that the employer employed him on a stipulated salary and that he worked for the employer during the relevant period. It is for the employer to prove not only that he paid the employee his salary for work done by the employee in the relevant period, but also how much the salary was that he paid the employee. The claimants having not shown that they worked for the dependent from the date of stoppage of their salaries to the date of judgment have failed to prove entitlement to relief B. It is interesting to note that in Keystone Bank Nigeria Limited versus Mr. Joseph Omoriopo, the Court of Appeal held thus: where the employment is wrongfully terminated, the employee is entitled to salary and entitlements over the period of notice. In this case, 1 month's notice. It is certain that once an employer takes steps to terminate a contract wrongfully, the contract still remains terminated. The court cannot find otherwise. It is contradictory for the respondent to assert he is still in the employment of the appellant and still claim the reliefs he did before the court. The decision in the Keystone Bank Supra maintains that once an employer evinces the intention to terminate employment and takes steps in the direction, the termination becomes effective, though wrongful. The word of Keystone Bank, it is right that wrongful termination remains a termination even from the date the wrong step was taken. In view of the foregoing authorities, the claimants cannot even claim relief V as the alleged stoppage of salary that terminated the employment of the claimant took effect in 2015 when the defendant evinces his intention to terminate their employment by stoppage of their salaries. The act of stoppage of salary, even if wrongful, has made the termination effective from the date of the stoppage. And so the measure of damages for wrongful termination, according to the decision in the case of Emego Vincent Ikemba versus Pyramids Company Limited, is the salary for the length of time for which notice of termination ought to have been given in accordance with the terms of the contract and not compensation or payoff. Incidentally, therefore, the absence of written terms and conditions of service, the court is left with no other option than to resort to the implied terms of the common law respecting termination of employment, which requires giving reasonable notice or payment of salary in lieu of notice for the period of notice. See Abu Kobo versus Africa Timber Plywood Limited. See Daniel versus Shell Petroleum Nigeria Limited. See Calabar Cement Company Limited versus Daniel. It is also to be noted that the claim being claimed for special damages must be specially and strictly proved, having found that there is no concrete evidence to establish the claim. The claim of the claimant must fail. All the other reliefs being ancillary to the main claim of allowances and salary dependent on grant of the main or principal claim. With the failure of the main reliefs, all other reliefs must also fail. the claimants have stated that they are entitled to be absorbed into the civil service of Cross River State, but there is no evidence adduced to establish the entitlement. They also stated that they presented their credentials but never informed the court their qualification or tendered the credentials for the court inspection to ascertain their qualification. This means they have no evidence to prove being entitled to be absorbed into the civil service of Cross River State. On the whole, the claim of the claimants failed due to lack of proof, and same is hereby dismissed. Decision on counterclaim. On the counterclaim, the third issue for determination is on counterclaim, whether from the facts and evidence in this case, the defendants' counterclaimants have proved their entitlement to the relief claim in their counterclaim. I have earlier in the judgment reproduced the relief being sought in the counterclaim. The law is right that a counterclaim is a separate and independent suit of its own. Therefore, just as the claimants have the burden of proving his case to be entitled to a grant of same, the defendant's counterclaimant must also adduce sufficient cogent, credible, admissible evidence in support of their counterclaim. CUAC Nigeria Limited PLC versus Akinyele, where also the case of Mobinson Interlink Associate Limited versus UTC Nigeria Limited, where the Supreme Court has this to say: a counterclaim is claim for relief asserted against an opposing party after an original claim has been made. That is a dependence claim in opposition to or as set up against the plaintiff's claim. See Black's Law Dictionary, 9th edition, page 402. In other words, a counterclaim is a claim by defendant against the plaintiff in the same proceeding. It is regarded as an independent and separate action in which the defendant counterclaimant is in the opposition on the plaintiffs and therefore has the burden of proving the counterclaim to be entitled to judgment thereon. As stated above, a counterclaim is separate and distinct action. Like all other claims, counterclaimant must prove their case against the person being counterclaimed before they can obtain judgment on the counterclaim. See Ogbonna by Attorney General Imo State. See Davuf versus Kolo and Obiamiri Brickstone, Nigeria Limited versus ACB. Thus, the counterclaimant must produce sufficient cogent evidence in proof of the counterclaim, without which they will not be entitled to such reliefs. The facts based on which the defendants' counterclaimants base their counterclaim are the unemployment of the claimants as ad hoc road marshals, and after completion of training, they were issued with skits to enable them to perform their function. It was also stated an interview and a certificate verification was conducted for ad hoc staff of the first defendant for purpose of absorbing them into the permanent employment in the civil service of Cross River State. The ad hoc staff who were successful at the interview and screening of credentials were absorbed in the civil service, and those who were not successful, including claimants, they were asked to return their keys, but the claimant failed and refused to return their keys. Instead, they were using them for illegal operation on the highway to extort money from unsuspecting motorists. In reaction to the counterclaim, the claimants, dependent to counterclaim, stated that they are qualified to be absorbed into the Cross River State Civil Service as permanent staff from first and second batch of the first defendant, ad hoc employee of the first defendant, and they have no questionable character in the discharge of their duties and are qualified for absorption and have presented their evidence of screening and have presented their credential for screening. The kits issued to the claimants are retained pending payment of their arrears of salaries owed to them till date. They also stated that they are still in service and being owed. They insisted that they return the work tools and uniform given to them by the defendant, and they paid arrears of allowance and salary owed to them till date. They claim they are still ad staff because they have not been disengaged by the first defendant. See paragraph 6, 4, 5, 6 of the claimant's reply to the defendant's amended statement of defense and counterclaim. From their pleading evidence before the court, the claimants defendant to counterclaim have admitted having been issued with kits when they were not employed as tools, when they were employed as tools for the work they were employed to perform. The evidence of the claimants defendants to counterclaim is indication that the claimant's defendant to counterclaim had, after absorption of successful staff into the permanent employment in civil service, were asked to return the kits issued to them, but they refused to return the kits as directed. The reason given by the claimant's defendant to counterclaim for not returning the kits issued to them is that they retain the kit pending when they are paid allowances, salaries owed to them by the defendant claimant to counterclaim. This is a clear admission of still being in possession of the kits. The law is tried that what has been admitted need no proof. In view of the admission of the claimants, dependent to counterclaimant, the dependent counterclaimant have proved entitlement to have their kits issued to the claimants, dependents to counterclaim to be returned. I hereby order the claimants, dependents to counterclaim to return to the first defendant the items issued to them when they refuse to return when issued to them when which they refuse to return, despite having been employed, having their employment terminated by the defendant counterclaimants. What the claimant dependent to counterclaim have succeeded in doing by retaining his kits issued to them is to resort to self-help, taking into their hands. Relief 3 of the counterclaim is a claim is in the alternatives. Having granted relief 1, relief 3 cannot be considered by this court. Relief 3 is being alternative, is being relief 3 of the counterclaim is a claim in the alternative. Having granted relief 1, relief 2, having granted relief 1 and 2 of the counterclaim, relief 3 being an alternative cannot be granted. Relief 4, 5, 6, and 8 of the counterclaim claim they have not been or reliefs 4, 5, 6, 7, 8 of the counterclaim, they have not been proved, as there is no evidence adduced in support thereof. With the grant of relief 1 and 2 of the counterclaim, relief 9 has become spent since an order for return of the kit has been made. Relief 9 has become otiosity. On the whole, the claimants have woefully failed to prove entitlement to any of their reliefs, while the defendants, counterclaimants, have proved entitlement to grant of reliefs 1 and 2 of the counterclaim. In view of the foregoing, the claimants, dependent to counterclaims, are hereby ordered to return to the first defendant the kits contained in relief 1 of the counterclaim. I make judgment is entered accordingly. I make no order as to cost, parties to bear their respective costs.
As the court pleases.
My lord.
Yes. You have to unmute. You have to unmute your. You have to unmute your speaker. For you to talk, you have to unmute your speaker.
Yes, my lord.
Your speaker is mute. You have to unmute your speaker if you want to talk. Unmute.
May I
Unmute your speaker.
Next one.
Yes. Yes. You have to unmute your speaker. Your speaker is muted. Unmute your speaker from your own device. Okay.
Modern facilities.
Yes. Registrar, call the next case.
Please. Suit number NICN CA13-2018 between Aqua de Henry Omang Esquire. Niger Delta Development Commission.
Appearance.
3. Mr. Usima Ekwe.
Mr.
4. Mr. Godwin Judge.
I can't hear you, counsel. Yes.
May it please this honorable court.
Yes.
My lord, my name is Ozinko Ozinko.
See, my
Yes.
lord.
Yes.
The parties are all absent.
Okay. Appearance.
May
Mr.
it please this
Ozinko?
honorable. Yeah, may it please this honorable court.
Yes.
My name is Ozinko Ozinko.
Yes.
A humble appearance is for the claimant.
Yes.
Thank you, sir.
Yes.
May you please, my lord?
Yes.
My name is David Obande. My appearance is for the first defendant.
Yes. Any other appearance?
Dafe Esquire.
The other
Dafe.
defendants. Any representation for them?
May it please, my lord, my name
Yes.
second, 6th, and 7th defendants.
I did not hear you very well. Yes. Appearance.
My lord, my name is Dafe. I appear for the 2nd, 6th, and 7th defendants.
Yes.
You carry earphone.
Yes. Any other appearance?
Neil, sir.
Okay. Yes. This matter is for adoption of final written addresses.
Yes, my lord. My lord,
Yes.
my lord, we were served with a motion for extension of time. The claimant was served with a motion for extension of time.
By who?
Along by David
I can't
Obande.
hear anything.
That is
Okay.
the first defendant's counsel.
Yes.
Instead of that particular motion, alongside with reply on point of law.
Okay.
My Lord, we also filed a reply.
Yes.
Reply to second, to 6th and 7th defendants' final written address.
Yes.
We are not opposed as to the motion for extension of time. We are also ready for adoption, sir.
My Lord, for the first defendant, the claimant not opposing the application for extension of time, may we move our motion for extension of time filed on 29th?
I'm coming. I'm checking the processes to confirm.
My Lord, it was filed on the 29th of October, but on the face of the motion paper, it reads, 29th of September, but on the face of the motion paper, it reads October. Lord, I understand it was sent over the weekend to my Lord.
Yes, I have the motion for the first defendant, which is seeking for extension of time.
Yes, my Lord. My Lord, there being no opposition, may we move in terms, my Lord.
Your motion is for
The extension of time within which the first
file reply on point of law.
Yes, my Lord.
Huh?
Yes, the file reply on point of law.
But I don't have your final. Have you filed your main address?
Yes, my Lord. We filed our main address on the 13th of July, 2023. And even though I don't have the
Mr. Ozinko,
Yes, my Lord.
any objection?
My Lord, there is no objection as for the motion for extension of time.
Okay.
Yes, sir.
Mr. Dape?
We've also filed our reply. Our reply to the 2nd to 7th defendants' final address.
I don't have those ones. I don't have your reply.
Okay. My Lord, I
seen your
believe,
reply.
believe is at the...
Mr. Dape, are you objecting? Mr. Dape?
My Lord, I'm not opposed. Lord, I'm not opposed to the motion for extension of time filed by the first defendant.
Okay.
Thank you, my Lord.
Okay. The application is granted as spread.
As the court
pleases. As the court places.
Yes, which application is the next?
My Lord, there is no application, only that my Lord is saying you don't have our reply.
Yes, I don't have that reply. But when did you file it?
Today. My Lord, it was filed today.
And so how do you expect me to have it? Not possible. We'll give you that next week so that you come and adopt.
As the court pleases. As the court pleases.
My Lord.
Give me date next week for them to come and adopt.
Next week, don't worry.
My Lord.
Yes.
We have a lot of adoptions next week.
How many adoptions?
We have adoptions, my Lord. 1, 2, 3, 4, 5, 6, 7, 8.
How can you put 8 adoptions in 1 week?
My Lord,
why?
You gave me to fix them. You know, we moved them from June.
From Monday, I'm free till when? 9th. I don't have.
Which date do you have after next week? Yes. Don't waste time.
That's all.
It's Friday.
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 My Lord, if Thursday, which is 5 this week, is convenient, or Friday 6 is convenient. Like that,
not this week.
1st of December.
Not this week. No. This is an old case, 2018. It has to be concluded this year. It's an old case. It has to be concluded this year.
Yes, my Lord. Okay, my Lord. My Lord, November 11. November 14. My Lord, November 14.
November 14.
Is it convenient, counsel? Is it convenient for you?
4th November.
11 November. You said?
November 14. 11 is this.
Okay. 14th of November. Is it convenient for you?
Yes, my Lord. Lord, I just wish we would have adopted at once. There's nothing.
I can't take adoption when I don't have the process before me.
As the court pleases.
I have to see the process.
As the court pleases.
This case is adjourned to 14th of November 2023 for adoption of final written addresses.
As the court.
I will deliver judgment by the grace of God this year. Don't worry. What's the next case?
That's one. NICN CA 27/2022 between Benedicta Patrick Ariko Esquire and the government of Cross River State, to the Attorney General of and Commissioner for Justice, Cross River State, 3, Cross River State Judicial Service Commission, My lord, the party are all.
Yes, appearance.
Second, we are in the National Industrial Court.
Appearance.
Okay. Virtual.
Please, counsel that has finished, you can mute yourself, please. Yes, appearance in Benedicta Patrick Aripo versus Government of Cross River State and two others. Appearance. Appearance. No appearance.
My lord.
My lord.
Yes.
I'm Solomon Abuo. I'm the claimant.
Okay. No, not Solomon. The case that was called was Benedicta Patrick Aripo.
Okay. Sorry, sir.
Benedicta Patrick Aripo.
My lord,
Yes.
Dr. Cassie was online and Barrister Aripo was online. I don't know if they have logged out. They were both online, my lord.
No, doctor is still online, but he has muted himself.
Okay, Dr. Nkasi is still online, my lord.
Yes, but he has muted himself. He has to unmute himself. Yes, appearance. Yes, appearance. Counsel, where you are, there is no service. You are not in a good place where there is service. You have to be in a place where there is good service, network service, for you to be able to do this thing. Where you are, the network is poor and you have muted yourself. Yes.
Hello, my lord. My lord, I just
Yes.
contacted Barrister Aripo, the counsel to the claimant. He said they are trying to reconnect. Their network has issue. They are trying to reconnect, sir.
Okay.
If maybe that case can be stood down.
No, we have other things to do. We can't stand down online matter unless I give you date. You come back, I give you another date.
My lord, considering the time it took for us to get to this point, sir, they are trying to reconnect. But
Yes, they should have connected earlier. They should have connected in time.
My lord, but Aripo has been online since the commencement of the court hearing this morning. It has been online since for hours.
Yes, Dr. Nkasi. We can't hear you. We can't hear you. We can't hear you, doctor. Your network is very poor. You better get a place where there is good network. You better go to a place where the network is good.
Can my lord hear? Hello, my lord.
Yes, your
Hello, hear
network.
me?
I can't hear you. Your network is not good.
From where I am, my lord.
Well, I will give you date. You come to the.
Hello.
I will give you another date. You come to the open court. Registrar, which date can you give them?
Lord, we'll give November 16.
Which day is November 16?
My lord, is a Thursday.
My lord. My lord, sorry, my
Yes.
lord.
Yes.
My lord, may I humbly enter my political appearance for the claimant and PO sir.
Mr. Aripo. Mr. Aripo. Mr. Aripo. Mr. Aripo.
Yes, my lord, PO
Yes,
for the
I have
claimant, sir.
recorded you. I have recorded you, but the way
Yes, my lord.
you are and where you are, it won't be convenient for you to conduct this matter. And the counsel for the defendant, Dr. Nkasi, is having problem with his network. So in the circumstances, I will give you a date so that you come to the open court and adopt your final written address.
It's okay, my lord.
This case is hereby adjourned to 16th of November 2023 for adoption of final written addresses.
As a cop, please. My lord, did you say 16th? 16?
Yes.
16.
Thank you, my lord.
You are welcome. Call the next case.
Suit number NICN CA28-2022 between Solomon Orem Abo Esquire and 1. Government of Cross River State, 2. Attorney General and Commissioner for Justice, Cross River State, 3. Cross River State Judicial Service Commission. My lord, the claimant is
present.
Is present.
Claimant is
Why did
online?
My lord? Yes, my lord.
Appearance?
My lord, I am PO Aripo. My humble
Yes.
appearance for the claimant on record, sir.
Yes.
My lord, our apology for her absence. She is sitting this morning, sir. We are very sorry.
All right. Yes. Dr. Nkasi, has your network improved? I think Mr. Aripo.
Yes, my lord.
Mr. Aripo,
Yes, my lord.
in view of the poor nature of Mr. Nkasi's network, I think we adjourn it to the same day so that we take all of them in open court.
As the court pleases, sir.
This case is hereby adjourned to 16th of November 2023 for adoption of final written addresses.
As the court pleases. My lord, we are much obliged. Thank you, my lord.
You are welcome. You are welcome. Registrar, any other case?
That's all, my lord.
Okay, counsel, we thank you for being with us, for being patient with us. We have come to the end of the virtual sitting. We thank you very much. The administrator, you can end the sitting.